Petition is allowed.
Is your lordship. But I make to mention item number 10 and 11 of today's list, lordship. But taken consent from the other side also.
Lordship, I'm for the respondent in item number 10 and 11. Lordship, a date may be fixed, Lordship. This is a very old matter.
Yes, we
But
always
yes,
fix dates.
Yes, Lordship.
Given agreed date.
Lordship,
And I
it
guess
will be on 12th March, Lordship.
Yes. Hearing day.
another prayer, lordship, item number 21 of supplementary list, lordship.
Yes. Same.
Same, lord.
Your lordship, can it be put on 17?
All right, 17 March.
Obliged, lordship.
To mention adjournment in the supplement.
Did it.
Well, case study was called for.
In this case, there was called for, but lordship, we have not received the CD, lordship. We have not received the CD, lordship.
Maybe in the course of the day. Any chance?
Lordship, because it will come from Raspberry PS, so after tomorrow, lordship, we can try.
My lord, two cases are there, my lord. Two CDs are necessary, my lord. Cross cases there, my lord.
I think it is called for. Raspberry PS 283.
And 284, my lord.
This is relating to which?
The same, my lord, the same subject matter, my lord.
No,
Both the
which
part-
PS case?
PS Polaspari, my lord. Both the cases from the same incident.
Why two police cases? Cross case.
Yes, my lord. Same day it was lost, my lord.
That is what I am saying. This is
Yes.
284.
28, yes.
283 has already been called for.
Yes, my lord.
Yes. He did not receive leave. For tomorrow.
Later tomorrow.
Obliged,
Obliged, my lord.
It pleases your lordship. This is a fit case, lordship, because it is on quantum. It is on quantum, it can be referred, lordship.
As agreed to by learned counsel for the parties. The matter is referred for mediation. To what mediation center?
High Court Mediation Center.
Referred for mediation to the High Court Mediation Center. Period. Parties are to be, date is to be given for the appearance of parties.
They will, or lordship can give, or they will be giving the notice because they send a notice.
All right, let it be that way then.
Yes, lordship. Otherwise, lordship can also give for appearance.
The mediation center shall notify the parties accordingly. Court of mediation be submitted by when?
After 60 days, lordship, because that is the
Practice.
that is the rule, that is the law.
So should we fix this case after 60 days?
Lordship can, no issue.
Is the matter again on after 60 days?
Okay, so no, next to Murias. Lordship, this is also a fit case from our side to refer to mediation because it is on quantum only. Same order.
Agreed? Yes, same order.
Highly obliged, lordship.
Obliged.
Your arguing counsel is on legs on some other court, court number 1, my lord. Ken Chaudhary, sir.
Can it be taken after some time? Since the other side is also not present. Obliged.
Lordship.
May I
Please
please?
go to the CD Lordship after some time Lordship may can call. Step aside Lord.
May I please, your lordship? Here, your lordship, as per the order dated 1/12/2025, we have published notice on newspaper, the Assam Tribune. As per accordingly, we have filed an affidavit, your lords, along with the newspaper publication.
This is an IA for what?
I for actually, your lordship, paper publication, notice of paper publication on paper.
Field. Learned counsel for the applicant. Appellant, stroke appellant. So. Passed in the. Order dated 1/12/25 passed in the instant IA. The notice to the respondent was published in the Assam Tribune newspaper on, what is the date?
On
22nd December 2025. Accordingly, affidavit has also been submitted along with the newspaper of the said date. On perusal of the same, the service upon the respondent number, only one,
One only, your lordship.
the sole respondent is deemed to be complete. By instance disposed of accordingly. Is the appeal for hearing. Is it admitted already?
Yes, lordship.
PCR is here.
Yes. That may be fixed, your lordship. Marshal.
May I please, Your Honor. But I am for respondent number 1 and 2, my lord. Has already died, my lord. But I have also got information, my lord, appellant also died, my lord.
Document. Death certificate. When did appellant die?
My lord, I have not, could not collect the exact date and yes, my lord. Sometime wait for collect.
None appears for the appellant. Learned counsel for the respondents submits that the respondent number 2 has expired, and it is his information that the appellant has also expired. However, however, there is no document in this regard available with learned counsel, who prays for some time to obtain the same. Is the matter. For 2 weeks.
Most obliged.
None appears for either side. Is the matter again on day after tomorrow according. মাৰ্চ ইমান দিব নালাগে, এইটো উইকতে লাষ্টত দি দিয়ক আজি। Sir, Vallabh Kotogi is in this case. And appears for the appellant. The cause list. Appellant as well, or respondent. Huh? I order করা আছে না একবার? মেনশন মেমো আছে 28 জানুয়ারি।
Hey, please, your lordship. I'm for the respondent in item number 12. This matter pertains to lordship, loss of the consignment delivered at NGC station, lordship. Made a prayer for compensation of the loss before the Railway Claims Tribunal. And the Railway Claims Tribunal had awarded the decree in favor of the respondent. And against that order, the appellant railway challenged the judgment, into judgment dated 10/5/2016. Otherwise, this case is purely covered with the decision of this honorable court in number of cases, Lord. Recently, the Honorable Gauhati High Court in MFA 19 of 2012 have passed a judgment in favor of the respondent claimant, where the issue involved in this case is squarely covered, Lordship. A humble submission, Lordship, since the counsel for the appellant is not present today, last chance may be granted to them, and Lordship, a date may be fixed in this case.
Name of railway is not shown. Maybe those council are no longer with railway.
Lordship, all matters were given to Mr. D.K. Day. Here, the counsel name is there, Lordship, in the cause list. The conducting advocate, Mr. D.K. Day, is there, Lordship.
He's with railways.
Yes, Lordship. Matters are with the central government council, but Lordship, matters related to all matter, Lordship.
None appears for the appellant railways, although the name of learned counsel, Mr. Day, is cause list by learned counsel. That Day is presently handling the NF railway. Is the matter again on the date?
Can it be on 24th Feb? 24th? 27th is Friday, 26th.
May it please your lordship. My lord, I am for the respondents, my lord, against the concurrent findings of the trial court regarding the bona fide requirement, tenants before this civil division petition before this court. And my lord, this matter earlier also, my lord, 2,275 days they were dismissed for default by this honorable court on 4/1/2019. Same has been restored on 7/11/2025. They are the tenant, they are enjoying our land, my lord. So it is very urgent matter, my lord. All the occasion, they either they took time or not represented. So I am praying for your lordship, some order may be passed today. Lordship, it was restored on 7/11/25. In I number 1534/2025 on similar conduct.
When it was dismissed for default earlier, order dated
My lord, 7/11/20 dated my lord 4/1/2019.
that none appears for the petitioner. Third learned counsel for the
Respondents.
respondents. Perusal of the record shows that the instant petition was dismissed for default for non-prosecution on 4/1/2019,
And restored on 7/11/25.
and the same was restored. Also not there,
In I, my lord, 1535/25. I.
restored by order dated
7/11/2025.
passed in I number.
I number 1534/2025.
Subsequently, the matter was listed again on 15/12/25, on which date also none appeared for the petitioner,
My lord.
and this court passed an order giving one more chance to the petitioner. However, today also none appears for the petitioner. Accordingly, the matter stands dismissed on prosecution.
Yes, obliged, my lord. Deeply obliged.
Interim order, if any, stands vacated.
Deeply obliged, my lord.
Yeah, really lost it. In this case, I am the appellant, my lord. So as per the direction of the honorable court, it is revealed that by the order dated 23/7/2024, I have filed only my written argument, and I was paid for submitting some documents, relevant documents to support of my written argument. So today I am submitting my the judgments in support of my argument, my lord. Written argument already I have submitted. It is the claim against the railway RCT, the imposed judgment dated 30/11/2018, passed by the Railway Claim Tribunal in way number 32 of 2016, and along with the common order dated 21/10/2016, passed in miscellaneous application number 17 of 2016. But in this case, one the more core issue, whether the applicant or respondent is entitled for the refund of the siding charge or not, this issue was not framed by the RCT. But without framing the issues, they passed the judgment and directed the respondent to refund the side amount of more than 2 crores 98 lakh something to the respondent as the railway recovered the siding charges. So I have denied this challenge the judgment in my memo of appeal also in taking by various grounds, and my written argument also I submitted everything, my lord. Now, my lord, I like to submit some decisions in support of my written argument, whether railway is entitled to recover the siding charges, and it is the respondent is.
Where is the written argument? Is it available?
My lord?
Written argument is available here in the
Yes,
record.
already I submitted, my lord. On 20 in the year 2024, my lord, it is reflected in order dated 23/7/2024. Had Mrs. U. Chakoti Lane, senior counsel of the for the railway, and also had Mrs. M. Sharma Lane, counsel appearing on behalf of the respondent. Mrs. U. Chakoti Lane, senior counsel, has submitted written argument, and she prays for some time to place some judgment passed by the court as well as the Honorable Supreme Court. Mrs. Sharma, Ms. Sharma, Lane counsel for the respondent, submit that this is an old pending matter, therefore no further chance will be given to the appellant.
Oh, this is your written argument.
No, I have submitted my, no, my lord, this is not my, written volume is big volume, my lord.
This is small.
Written argument submitted by me, my lord. It is by big
Written
volume.
argument submissions on behalf of the appellant along with relevant railway board circulars, letters,
Yes,
etc.
yes, my lord.
Lordship, today I'm going to file written argument in this matter.
My lord, today I am going to file my some relevant judgment in support of my written argument, my lord.
No oral argument is required.
Not ridiculous.
Because Lordship, here the matter is purely technical, Lordship. That's why, Lordship, for the convenience of the court, I have placed my written arguments. Similarly, the counsel for the appellant also placed her written argument, Lordship. But the issue involved in this case is purely technical, Lordship. First of all, Lordship, the issue is related to whether the railway is entitled to collect siding charges. Whether, Lordship, they have issued some letters where they have admitted that on that period of time when the consignment was booked, that time, Lordship, siding charges were not leviable, Lordship. But they have collected from the respondent, Lordship. So our claim is, Lordship, since on that period, Lordship, siding charges were not leviable, then, Lordship, we made a claim before the railway administration seeking refund of siding charges. And in regard to that siding charges, Lordship, the CGS, the Chief Goods Superintendent of Numaligarh Siding, Lordship, they have also issued one certificate where they have admitted that this much of amount is payable to the Numaligarh Refinery Limited. On the strength of this letter, Lordship, certificate issued by the Chief Goods Superintendent, Lordship, we have placed our claim letter, made our claim letter before the railway administration. And on that basis, Lordship, the learned tribunal have awarded the decree in favor of the Numaligarh Refinery, Lordship. So here the issue which was framed by the learned tribunal, Lordship, is based on the consent of the both parties, Lordship. While order dated 19/1/2017 of the learned tribunal, Lordship, the following issues were framed, Lordship. First issue is whether this court has jurisdiction to decide the claim application. Second is whether the valid notice issued by the claimant, and third is relief and cost. Lordship may kindly peruse that order, Lordship. And on the basis of the consent of the both sides, Lordship, the issues were discussed and accordingly order was passed, Lordship. Now, Lordship, here now the learned counsel for the appellant submitted that the certain issues were not framed. That issue is now, Lordship, already they have exhausted that prayer, Lordship. That prayer was now gone, Lordship. Now the issue is, Lordship, whether the railway is entitled to collect siding charges or not. Because once they have admitted that the certain amount is payable to the Numaligarh Refinery, now they cannot deny that submission by that fact, Lordship. This is my humble submission, Lordship. If Lordship permit, then the matter may be kindly dealt with the merits of the case, Lordship, because here the matter is purely technical, Lordship. So each and every document needs to be perused, Lordship.
My lord, in this case, the Granland RCD in judgment dated only framed two issues. Whether the court has the jurisdiction to decide the claim application and whether the valid notice issued by the claimant, the relief and cost. But now they are claiming the refund of the siding charges. The rail is not entitled to collect the siding charges, which is as per their this is technical. But as per railway circular, railway is entitled to collect the siding charges for difference of 9 kilometers because it is railway siding. So, my lord, it is the duty of the RCT that to frame the issue on the entitlement, the respondents and applicant, the claiming refund of the overcharges or siding charges as collected by railway as the authority of the respondent applicant to prepare application for claiming refund of the siding charges collected by railway to the extent of rupees 2,98,22,483, but had allowed the claim of the respondent applicant under issue number 3, which is not framed. Hence, decision taken against the issue number 3 is not tenable in law and liable to be set aside and under cost, my lord. Until unless issue is framed, my lord, they pass this.
Where are the issues? Which page?
In judgment, my lord.
Mm.
In memo appeal, annexer 1, at 11, main page is 13, and the issues frame in page 17 of my memo appeal. On the para 5, on the basis of the pleading of the parties, the following issues were framed for determination whether court has a jurisdiction to decide the claim application, whether the valid notice issued by the claimant, reliefs and cost. So it is the duty of the RCT that to frame the issue whether the respondent or applicant is entitled to get refund of the siding charges collected by the railway. This issue, without framing this issue, they observed that pass this judgment, my lord. It is the violation of the legal provisions of the law. Without framing issue, objection cannot be made and cannot pass any order or judgment. In issue number 1 and 2, they have decided whether the claimant is entitled for siding charges or not. Without framing issue, they observe in under issue number 3, but issue number 3 is the relief and cost. Actual issue is not framed. In my written argument, I have read already all objection and about the relevant document of the Railway Board circulars and the various judgments of the Honorable Court and Supreme Court, my lord. So I have challenging this impugned judgment of the RCT, which is on record, my lord. Moreover, the certificate issued by the numerical refinery railway already denied. It proved that the appellant and railway authority have never worked out and prepared any overt charge sheet in the form of LS certificate statement dated 7/1/2013 as claimed by the respondent applicant. This was not prepared by the railway. However, by ignoring this said condition, learned RCT had erroneously came to the conclusion that sidings are so collected by the railway was illegal, and hence the impugned judgment is bad in law and liable to be set aside. It is I have taken this ground in my written argument also. In my memo appeal also I have taken grounds. So without framing an issue, core issue, this is the core issue, what they are claiming refund. So this issue was not fit. It cannot be passed in judgment under issue relief and cost. Relief and cost, whether after made observation under issue number 3, where to be framed on the ground that whether the applicant respondent is entitled to get refund of the siding charge as collected by the railway. But this issue was not framed under issue number relief and cost. Observe this matter, my doctor, which is not tenable in law. It is when they are claiming refund of the siding charges, it should be core issue to be framed by the RCT. RCT failed to frame this issue.
How far is the RCT bound by the provisions of the CPC?
No, there's a Railway Claim Tribunal Act, my lord. There's a provision to frame issues. My lord, in section 18, procedure and powers of the claim tribunal. The claim tribunal shall not be bound by the procedure led by the Code of Civil Procedure 1908, but shall be guided by the principle of natural justice and subject to the other provisions of this Act, and any rules. The claims tribunal shall have a powers to regulate their own procedure, including the fixing of the places and times of its inquiry. The claim tribunal shall decide every application as expeditiously as possible, and ordinarily every application shall be decided on a perusal or document, written statement, written representation, affidavit, and other hearing and oral argument as may be advanced. In this case, we have filed, railway filed written statement, evidence on affidavit. Everything has been filed before the RCT.
So the CPC is not applicable.
Not applicable.
So
It
he
is
is not bound to frame issues.
No, my lord. Not if not bound, the claim tribunal shall have the, for the purpose of discharging the function under this act, the act, the same power are vested in a civil court under the Code of Civil Procedure while trying a suit in respect of the following matters mainly. This A, summoning and enforcing the attendance of the person and examining him on oath, requiring and discovery of the production of the document, receiving evidence on affidavit, and issuing commission for the examination of the witness or documents, reviewing the decision, dismissing the application, dismissing the application default in a so setting aside in order dismissal, any other matter which may be prescribed. As per section 9, 18(3), the claim tribunal shall have for the purpose of discharging its function under this act the same power as are vested in civil court.
Having the power and exercising it are two different things.
My lord, though
When it expressly says that the provisions of the CPC are not applicable,
but they have
can you
power
say
as per
that
the CPC.
it has the power, it can frame issues, it has framed issues,
My
but
lord,
it may not frame issues in the manner that you would have liked under a normal civil proceeding,
yes, no, my lord, my question
as
is,
long as the issues are discussed in
then
the judgment.
if that condonation of delay, the 8 years, 5 months after expiry of the 8 years, 5 months, they file the claim application. We have in the claim, the for, application for condonation of delay, we filed this written objection to this petition for condonation of delay, missing application of 17 of 2010. My lord, in this case, they RCT condoned the delay. If when the condoned delay is condoned, then why this fresh issue was framed, why the valid notice is there or not? This may be wrong.
How is it connected?
My delay is if my delay is condoned.
Condition of delay concerns the reason which prevented the petitioner or applicant from
Yes,
approaching the court.
Yes. My,
What has it got to do with notice?
yes. If my notice in valid period, they could have filed this application within the period of limitation, but they have filed after expiry of 8 years, 5 months.
That boat has sailed now. You didn't challenge that.
No, they already delay is condoned. But when the delay is condoned, they have framed this issue number 2, whether there is a valid notice or not. If delay is condoned, question of valid notice doesn't arise.
So firstly, you are aggrieved by the non-framing of issues, and secondly, by the framing of issues.
Nah, again,
This
yes.
issue, yes.
This is the
That
main
is on
point.
merit, all right.
Now the my allegation is that they are not entitled to get the refund of the siding charge as collected by the railway. On which ground I have already mentioned in my memo appeal in my written argument also. Now it is up to lordship.
So it is. So you have submitted on merit as well,
Yes, my lord.
not only on the point of non-framing of issue.
No, my lord.
Well,
On the basis of the merit, I have filed my written argument, and it is in support of my written argument, I am citing my decision, relying on a decision of the Honorable Supreme Court. This I am submitting, my lord. My lord, another item number 15 is a cross appeal. They are claiming the refund, enhancement of the interest. In this case also, I have filed my written argument. They are not entitled for the enhancement of interest on the basis of various judgment of the Honorable Supreme Court and this Honorable Court also. In one of the case, this Honorable Court already dismissed their appeal on the ground that they have no power to enhance this enhance the amount of the interest, any percentage of the interest. In
so
MFA,
14 is over.
item number 15.
14 is over.
14 is over, my lord. Because my written argument will say which he, my lord.
Lordship, I would like to make submissions in item number 14, Lordship.
Yes.
If Lordship permit me, Lordship, here the appeal is challenging against the judgment and order dated 30/11/2018, Lordship, as well as the common judgment and order dated 21/10/2016. They have challenged two order in the appeal, Lordship. First order, that is 21/10/2016, pertains to Lordship order passed in the delay condonation application. That period of limitation is over, Lordship. They cannot prefer that order, Lordship, challenge that order in the main appeal, Lordship. So this appeal is not maintainable. Second, Lordship, they have again challenged the order dated 30/11/2018, which is the impugned judgment, Lordship. And here I would like to read the judgment, Lordship, before your Lordship. This judgment says, Lordship, if Lordship permit me, may I read?
All of it. The whole judgment you want
Yes,
to read.
Lordship. Lordship will get the idea what is the case actually, Lordship.
Get it even by reading.
Or else, Lordship, I would like to read from issue-wise, Lordship. Because here in issue number 1 and 2, Lordship, here the first issue is whether the court has jurisdiction to decide the claim application, and second is whether the valid notice issued by the claimant is correct or not, Lordship. Here issue number 1 and 2 are jointly decided, Lordship. Here from para 8, I would like to read, Lordship. From the facts of the case, it is clear that the applicant is a Government of India undertaking which is trading in petroleum and petroleum products, and lot of their transportation requirement is done on Indian Railways. In this case, the matter for condonation of delay has been dealt with wide order sheet dated 21/10/2016. After the delay was condoned and a new number of the original application comes, the case will have to be viewed on its merit, and question of whether the court has jurisdiction to decide the claim application will not be of any relevance. Para 9. It is settled law that once the condonation of application for delay is finalized, the only issue left to be discussed is whether the case merits consideration and not whether a valid notice was issued by the applicant or whether the court has jurisdiction to decide the claim application. In this case, it is seen that the issue is in correspondence between both the applicant as well as respondent since the year 2001, and the present claim has its roots from the time the first order of notifying the NMGS Numaligarh refinery siding on distance basis was issued on 11/2/2001. The issue remained under correspondence between parties all this while and was also not settled by the respondent either way. In such a situation, when the case initially came up for discussion, condonation of delay was first taken up, and once that issue was decided, the case was processed, and as such, at this stage, there seems no reason to even question the jurisdiction of the tribunal to decide the claim. The applicant has remedy available under Section 15 and for cases transferred from RRT under Section 33 of the Indian Railway Act 1989. As such, claim has been rightfully dealt with by the tribunal. The judgment of Honorable Supreme Court dated 5/2004 reported in AIR 2004 SC 3079, Civil Appeal number 10612 to 1062 of 1998, referred to by applicant also confirms the same. In view of the above, issue number 1 and 2 are decided in favor of the applicant. Now, the main issue is issue number 3, Lordship. Para 10. From the facts of the case, there appears to be lack of clarity on the part of both the applicant as well as respondent in dealing with this case of double payment. While the applicant initially filed a case for refund of 9 km excess charged from Numaligarh refinery siding to various locations and had supported the same by furnishing the statement of erroneously charged rate, page number 45 to 87, amounting to rupees 5 crore 4 lakhs 22,520. This claim was later modified for refund of siding charges after the clarification was issued by Chief Commercial Manager NF Railway to CGS NMGS on 8/7/2009 for overcharging of freight on account of so-called siding charges. It is apparent that even the applicant kept on changing his plea for refund of overcharges. initially for overcharge of distance for rupees such and such, and later on seeking refund of siding charges paid amounting to rupees 2,98,22,483. From the facts available on the file and the evidence adduced by both the parties, the sequence of the case is given below. Para 10.1. The first relevant letter issued by the respondent was Goods Circular number 92/2001 dated 23/11/2001, wherein two facts were brought out. One, that NMGS will henceforth be treated as a siding for through distance basis, as it has the facility of handling full rake. There was also a provision in the same letter that in case placement is made by reversing the engine and pushing the rake into the siding, the revised system of charging on through distance basis will not be applicable. There is also a letter dated 21/10/2016 on record issued by the CGS NMGS, wherein he has brought out the working arrangement regarding placement of BTPN wagon in the NMGS. It states that after the BTPN wagon comes to the gate point, NMGS staff opens the gate, power is detached and reverse, and entire rake is pushed back for placement on the gantry line for loading. It is also on record that for recovering the siding charges, a trip trial was conducted between 10/2/2001 to 11/2/2001 by officer level committee specifying the trip time, which as per the joint report was calculated from serving station NMGY to siding station NMGS with empty wagons and return up to NMGY with load, totaling to 2 hours and 20 minutes. As clarified in various communications of railways on record, NMGS is a loading point and that the inward wagons movement required is only for empty wagons to be placed inside for loading. The empty wagons are pushed inside through reversal of the engine, and after the load is ready, the engine pulls it out from the siding station NMGS to serving station NMGY. For this to and from movement, the siding charges are leviable. It may be noted that this trip trial was done prior to the date of notifying this siding for through distance basis, and as such, on purely technical terms, the railway should have conducted fresh trials once again for the placement of empty wagons into the siding to recover one-way cost. In that hypothetical situation, railway would have had the right to recover the 9-kilometer charge added on through distance basis for the outward movement from NMGS to various destinations. There is clearly an element of flip-flop by the respondent railway in first saying that the 9-kilometer distance need not be charged, but later on modified by another letter dated 8/7/2009 by instructing CGS NMGS to realize freight on through distance basis by adding 9 kilometer, but siding charges should not be levied on the basis of trip time. The applicant, on the strength of this clarification, immediately revised their claim and sought the refund of the siding charges already paid. In view of the above submissions and the fact that tribunal cannot go beyond the claim filed, we are of the opinion that once this clarification dated 8/7/2009 is issued, the claim of the applicant gets firmed up for refund of siding charges as freight on through distance basis adding 9 kilometer has already been charged. It is seen that the documents in support of the claim for refund of siding charges filed by the applicant is a letter received by the applicant through the Information under Right to Information Act. The letter issued by CGS NMGS to ACM Tinsukia gives the basis of calculation of siding charges in Annexure 1, and the details of recoveries of siding charges made from April 2005 to July 2009 year-wise in Annexure 2, page number 299 and 300. Annexure 2 specifies the siding charges levied for the year 2005 to 6, 6 to 7, 7 to 8, 8 to 9, 9 to 10, up to July 2009. It also mentions the rates amount as well as the CR note numbers by which this siding charges has been paid. These documents have been filed by CGS NMGS and have been attested by Assistant Commercial Manager NF Railway Tinsukia. Since the remittance details have been furnished in these documents, there is every reason to believe of this being an authentic document. However, in the interest of the correctness of the claim being settled, The refund of siding charges for the period April 2005 to July 2009 is allowed with direction to the respondent to calculate the actual amount due for refund based on factual verification of amount of siding charges paid during this period. This issue number 3 as such is also decided in favor of the applicant. Now, Lordship, based on the RTI information, Lordship, we have made our claim, Lordship. And in that RTI, Lordship, they have admitted that this much of amount is payable to the NRL, Lordship. Now, Lordship, accordingly, on the basis of the information received under RTI, the learned tribunal have passed this award, Lordship. Now, Lordship, I would like to draw your attention to the RTI, Lordship, which Lordship may kindly be perused from the TCR at page number 81. In page number 81, the Lordship will find this RTI information. And this information was attested by the Assistant Commercial Manager, confirming the amount, Lordship, that is 2,98,22,483
Page 81 of what?
of the TCR. Trial court's record, Lordship. RTI reply letter dated 2/5/2017, Lordship.
Eighty?
81.
What is 81? Is 81 question? 88, 57, 82, even 81. This is 81. What is this?
No, Lordship, this is not the.
You annexed it anywhere else? The written argument or somewhere?
No, Lordship. File 2. In this RTI Lordship, 6 enclosures are there, Lordship. The next page, Lordship. 27/3/2017, the CGS and MGS have stated that the information sought by the letter mentioned under reference is enclosed as Annexure 1 and 2. And in Annexure 1, Lordship, here the basis of calculation of siding charges is given, Lordship. We kindly see Annexure 1, Lordship. Here, the definition of siding charges is there, Lordship. Siding charge is the amount which is charged against the engine utilization for the fixed time determined by trip trial method. Here at NMGS in line with trip trial joint statement by letter number NIL dated 10/2/2001, the time required for the trip to bring the rake from servicing station NMGY to NRL private siding. NMGS is 2 hours 20 minutes on every rake. Siding charges were collected separately as per rates prescribed from time to time by Railway Board. In NMGS, train engine is utilized for shunting. The siding charge bill was submitted on monthly basis. Now, Annexure 2, Lordship. The amount collected from booking station NMGS from April 2005 to July 2009 is as under. This amount also tallies with the certificate issued by then CGS NMGS Shri JP Sonwal on 7/1/2013. And on the next page, Lordship, the statement of siding charge, Lordship, from the financial year 2005 up to 2010, Lordship. 2005, 6, 6, 7, 7, 8, 8, 9, and then 9, 10, Lordship, is given, Lordship. And here the total amount is 2,98,22,480. And this certificate was earlier issued by the CGS JP Sonwal on 7/1/2013. And that certificate was later, Lordship, confirmed in this RTI. And it was attested by the Assistant Commercial Manager. Earlier, we have made our claim based on the certificate issued by the then CGS NMGS JP Sonwal on 7/1/2013. This certificate was later again confirmed with this information, RTI information, Lordship, that this certificate was rightly issued by the former CGS and MGS, Lordship. The same certificate was later reconfirmed by this RTI, Lordship. So on the strength of this certificate dated 7/1/2013, which was later reaffirmed by the RTI, the learned tribunal have awarded the decree of rupees 2,98,22,483 against siding charges, which was levied from the period 2005, April 2005 up to July 2009, Lordship. First of all, they have, Lordship, issued one letter, that is 11/11/2008. In that letter, Lordship, they are saying that siding charges were not leviable, only distance of 9 kilometers, that portion will be collected, will not be applicable. Only siding charges will be applicable. Then, Lordship, we made a claim for refund of the distance of 9 kilometers, which is about 5 crores. Then later on 8/7/2009, they modified the amount, and they are saying that distance will be applicable, siding charges will not be leviable. Then again, we have modified our claim, and we claim for siding charges to our claim letter dated 7/1/2013, annexing the certificate issued by the CGS, that is 7/1/2013, and later that certificate was reaffirmed by the RTI, Lordship.
No, all right. This RTI reply, it says this amount was collected from you as siding charges. What is the basis of the refund? Why the refund? You have utilized that engine?
Lordship, siding charges
Was there a double?
only levied by them, which is not applicable on that period, Lordship.
notification or whatever circular was issued afterwards
Yes.
for collection of siding
Yes, sir.
charges.
Siding charges were not applicable on that period of time when the consignments were booked. So they have gave one clarification letter dated 8/7/2009. In that letter, Lordship, they have admitted that siding charges will not be applicable. So they have instructed the officials to stop collecting that siding charges, Lordship. On the basis of that letter 8/7/2009, we have preferred a claim before the Railway Administration via our claim letter dated 7/1/2013, which is a mandatory notice, Lordship, under Section 106 of the Railways Act 1989. Since we have agitated our issue from 10/2/2001, Lordship, they have settled the issue in the year 2009, that is on 8/7/2009. And they are saying that siding charges will not be applicable. From 8/7/2009, we have preferred our claim on time and by annexing the certificate issued by the CGS of that period, Lordship, JP Sonwal, and the certificate dated is 7/1/2013. That certificate we have annexed with our claim letter and we have asked for the refund of siding charges. And thereafter, Lordship, the claim was filed before the Railway Claims Tribunal. And Lordship, on the basis of the information obtained under RTI, which is reaffirmed the certificate issued by the earlier CGS, Lordship, the amount will be, the amount was refundable to the applicants. Now, Lordship, this siding charges is an illegal charges, Lordship. Why it is illegal charges, Lordship? In my written argument, Lordship, I have annexed the judgment of the Honorable Supreme Court. Lordship may kindly see that judgment, Lordship. Let's say to judgments. It's not auto. In page number 24, Lordship, in the written argument, I have annexed the judgment of the Honorable Supreme Court passed in the case of Hindustan Petroleum Corporation Limited versus Union of India, decided on 14/12/2017. In this case, Lordship, the Honorable Supreme Court held that, Lordship, in paragraph 4, as well as in paragraph 5, 8, and 9. Very relevant, Lordship. Whether the notice under section 106, subsection 3 of the Railways Act 1989 is applicable in the case of illegal charges, Lordship, collection of illegal charges. We are saying that.
What you are reading? Which judgment?
Lordship, page number 24 of my written argument.
Hindustan Petroleum.
Yes, Lordship. Para 4, Lordship. The submission advanced by Shri K.V. Viswanathan, Learned Senior Counsel, appearing for the appellant, has been short and precise. Referring to the provisions of section 106, subsection 3 of the Railways Act 1989, the Learned Senior Counsel has urged that requirement of giving notice within 6 months from the date of such payment or the date of delivery of such goods at the destination station, whichever is later, is only in case of overcharge by the railways. The present, according to the Learned Senior Counsel, is not a case of overcharge, but is one of illegal realization of freight. This Learned Counsel, Senior Counsel contends that is on account of the fact that the freight was paid as per the fixed rate on the basis of the notified distance. There was really no overcharge. Subsequently, the distance was corrected and re-notified, which would make the realization an illegal one and not one of the overcharging. In that case, Lordship, distance was wrongly, illegally collected, and later they have modified the claim, Lordship. In the present case, they have that siding charges were illegally collected and which was later modified by letter dated 8/7/2009. Para 5. Learned Senior Counsel has relied on a decision of this court in Union of India Others versus West Coast Paper Mills Limited and another Manu SC 0191/2004. SCC 458 AIR 2004 SC 3079 to contend that the distinction between overcharge and illegal realization of freight has also been acknowledged by this court in the above case, which dealt with the pari materia provision contained in section 78B of the erstwhile act, that is the Railways Act 1890. 6. Learned Counsel for the respondent, on the other hand, has relied on a decision of this court in Birla Cement Works versus GM Western Railways and another cited in so-and-so to contend that the notice issued by the appellant to the respondent in the present case on 30th March 2011 was well beyond the period of 6 months stipulated under section 106 subsection 3 of the Railways Act 1989, and therefore the claim would be barred by limitation. We have considered the rival submissions advanced at the bar. Birla Cement Works Supra was a case where the petitioner therein came to know of the alleged excess amount of freight on wrong calculation of distance through a letter dated 12th October 1990 issued by the railway authorities. This primary fact is conspicuously absent in the present case. In the present case, what was paid was as per the fixed rate on the basis of notified distance, which subsequently was corrected by another notification upon introduction of the terminal mechanism system at Asaud Railway Station, District Rohtak, Haryana. On the other hand, in West Coast Paper Mills Limited, Supra, this court in paragraph 20 of the said report took the view that as the freight paid was as per the rates notified, the case would not be one of overcharge at all. If that is the view taken by this court on an interpretation of the pari materia provision in the S12 Act, that is the Railways Act 1890, we do not see why in the facts of the present case, which are largely identical, we should be taking any other view in the matter. Consequently, and in the light of the above, we allow the present appeals, set aside the order of the High Court. Lordship, in this case, Lordship, in the judgment Hindustan Petroleum, Lordship, the railway have wrongly collected distance, Lordship, which is then illegal collection, Lordship. On that period, distance is not applicable. In my case, Lordship, they have collected first distance, later which was modified in the year 2009, and now they are saying that distance will be applicable and siding charges will be not applicable, Lordship. So we are saying that this is a collection of illegal charges, Lordship. And in illegal charges, Lordship, collection of illegal charges, section notice under section 106 subsection 3 of the Railways Act 1989 is not applicable because it is an illegal charge, Lordship. So here the notice regarding claiming of refund of rupees 2 crore 98 lakhs, it is not applicable, Lordship. Even though we have made our claim after receiving the letter dated 8/7/2009. So far as notice is concerned, Lordship, this judgment is squarely covered. And so far as entitlement of the award, Lordship, the respondent have rightly placed their claim based on the certificate, and on that certificate, Lordship, the learned tribunal have awarded the amount. This is my humble submission with regard to the item number 14, Lordship. And in item number 15, Lordship, we have filed a cross appeal, Lordship. In that cross appeal, Lordship, the interest, we have claiming interest at the rate of 9%. Okay, divided.
$15.
We have cited few judgments also, Lordship. One is honorable judgment of the Honorable High Court in FA number 1 of 1987 in the case of Union of India versus Food Corporation of India. And second is Messrs. J.P. Reva Sivan versus Union of India, passed in MFA number 80 of 2002.
Now, what was your counterpart referring to? This matter has been already dealt with in another.
Yes, Lordship. Since the similar issue is decided in MFA 12 of 2009 by the Honorable Justice Mr. Budhi Habung Lordship.
Don't have to name the judge.
Sorry, Lordship. So in this judgment, Lordship, the claim for enhancement of the interest was rejected. If Lordship may see the judgment that I have cited in the written argument, Lordship, it is Lordship, up to Lordship wisdom, Lordship, whether this judgment may be considered or not, or otherwise I have no objection in with regard to this MFA 12 of 2019. One more thing, Lordship, in MFA 12 of 2019, here the claim of the NRL is with regard to refund of distance, which was admitted by them in the certificate dated. Here the certificate date is mentioned, Lordship. What is it? Certificate date. And based on that certificate, Lordship, the refund of distance was awarded by the learned tribunal, and the same was upheld by this court, Lordship. 6/12/2008 is the certificate issued by the CGS, Lordship, in this judgment, MFA 12 of 2019. This certificate is with regard to the statement issued by the CGS for the issue related to refund of distance, Lordship. On the basis of that certificate, the Honorable Court upheld the decree of the respondent claimant, that is NRL, Lordship. In the present case, Lordship, we have preferred a claim for the refund of siding charges, and based on the certificate issued by the CGS, Lordship, the claim was made, Lordship, before the learned tribunal, and similarly, the RTI also confirmed the same, Lordship.
You have been granted interest at what rate?
At the rate of 6%, Lordship. Para 26, Lordship. In the earlier judgment in MFA 12, Lordship, and in the present case, Lordship, here the in the present case, Lordship, interest was granted at the rate of 6% from the date of filing of the claim application, Lordship. And thereafter, after expiry of the 90 days, Lordship, then the interest will be increased up to 9%, Lordship.
Same as the MA 12.
Yes, Lordship, same.
So
In MFA 25 2019, this enhancement of this interest already dismissed, my lord.
Already.
Because already in my written argument has submitted that there is no any contract agreement or not, there is any provision to grant that. The RCT granted this interest its own power, my lord. So their concern of enhancement of the interest further does not arise, my lord. So my lord, as I am again repeating, my lord, so far item number 14, my lord, I humbly pray your lordship that to go through the railway board circulars, annexure 15, annexure 16. They are saying it is a illegal siding charges. Now railway is clarified, but is it illegal or not? In annexure 16 at page 10, 110. And annexure 110, 111. Annexure 12 also, my lord. Annexure 12, page 112, my lord. These are siding charges, how the railway is collecting, why they are collecting. They are made payment on the 31/7/2009, my lord. As per the RTI report, they are saying that they have discouraged this collection of the siding charges at 8/9/2009, my lord. So, my lord, that is it is not covered, not related with this case, my lord.
it is not related.
They are the RTI. When they are booking, when they have claimed the siding the siding charges.
RTI only says that we collected this much money for this period as siding charges. Yes. Whether he is entitled to collect or not, that is a different matter.
Different. They have collected.
Yes.
It is not denying. Now the my lord, after tracing all the old records available at Numaligarh Station Good Office, no such record regarding the statement showing the details of the freight refunded for the period 2007-2008 and details of the refund of the freight made against the erroneously charged or rate or chargeable distance to various location ex nobiligar are not forced at present. So the clarification is that, my lord, page 111, the clarification regarding 9 kilometer through distance booking. In terms of the CCM rates, Maligaon rates goods circular number 92 of 2001, dated 23/11/2001, all the consignments were booked from Numaligarh refinery project siding BG to different destination on through distance basis is by adding 9 kilometer, and siding charges were also collected at the fixed trip time of 2.2 hours at every rake. Siding charges were collected separately as per rates prescribed from time to time. But after receipt of the CCM rates, Maligaon official letter number so and so dated 11/11/2008, all the consignment booked by reducing a 9 kilometer from the chargeable distance with effect from 1/11/2008 to 21/4/2009. But siding charge were collected as per prescribed rate. After reduction of the 9 kilometer from the chargeable distance, error sheet were issued by the accounts department on the ground of error in distance. So again, 9 kilometer distance has been added to the chargeable distance, and siding charges were also collected as per prescribed rate. This is a clarification of the railway. Then, my lord, as per letter Railway Board Circular 6/2009 also, it is clarified why siding charge was charges, my lord. At page 112 and 113. In my written argument, I have annexed all the circulars, my lord. Why the railway collected the
Did you
siding
place
charge.
them before the tribunal or not?
Yes, my lord. In my written statement, already it is submitted, my lord.
There.
In the before the RCT railway filed the written statement, I have annexed here. Evidence on affidavit also here. So in my written argument, everything, my lord. So enhancement of the item number 15. So for enhancement of the interest is concerned, I filed my written argument along with the judgment, and they are not entitled to modify or enhance the interest. And RCT passed the granted the interest on the basis of its own view, my lord. And there is any provision under section 34 of the CPCO. There is no provisions for enhancement of interest, and under rule 31(2) of the railway claim tribunal procedure rules, my lord. So in this case, when there is any provisions, my lord, question of enhancement or modification of the interest does not arise, my lord. In my written argument, my lord, already I submitted, my lord. This is a written argument in item number 15. This is up to lordship now. My lord, if it is completed, my lord, I have been humble prayer, my lord. Item number 22 of supplementary list, I got in the night I have got the supplementary list, my lord. So item number 22, I have not prepared, my lord. It may be adjourned. Item
Please.
number 22 of supplementary list.
Already adjourned.
No, 22. Huh? 17 March of last.
Lordship, one more point I would like to add in item number 14, Lordship. One letter that is issued by the railway, that is 11/11/2008. Lordship may kindly make a note, Lordship. 11/11/2008. That letter, Lordship, will find at page 7 of the TCR. This is the letter when they have acknowledged that distance of 9 kilometer will not be applicable.
Letter dated
11/11/2008. In page number 7 of the TCR, Lordship, it is there. In this page 7. In this letter, Lordship, the railway have acknowledged that distance of 9 kilometer will not be applicable. Only shunting charges will be applicable. Then, based on this letter, Lordship, the CGS have issued some statements, Lordship, that we have annexed with the claim letter for the refund of 5 crores 98 lakhs. And Lordship, on 8/7/2009, which Lordship will find at page 80, 79 to 80, Lordship. So this page is, Lordship, regard to 8/7/2009, where they have remodified their statement and they have stated that distance charges will be applicable, but siding charges were not leviable. So on the basis of this letter 8/7/2009, Lordship, this is very important. We have made our claim, Lordship. So this is my humble submission, Lordship. This 2 letter is very relevant. And the RTI information dated 2/5/2017 and certificate dated 7/1/2013.
But you flag mark those pages
Yes,
because
Lordship.
this pagination is rather haywire.
Item number 13, my lord, I'm sorry, my lord. I was slightly, my lord.
What happened to 13?
13, my lord, it was.
So dismiss. Yes.
Pick up, my lord, I'm ready, my lord. I'm ready, my lord.
Yes, go ahead. Other side is there.
Senior is on Lex. Your
Let him come. Let's start.
My lord, this is suit for ejectment, my lord. Suit for ejectment of tenant. My lord, the trial court decided both issues, my lord, regarding defaulter and monetary requirement in favor of the landlord party. Now, appellate court, my lord, reversed the finding of the trial court so far defaulter point is concerned. Decree has been affirmed on the basis of defaulter.
The basis of?
Defaulter. I know, I'm sorry, madam, monetary requirement. Monetary requirement only. So I'm on the here, losses may come to appellate judgment. Which
So he was held to be not a defaulter, but the claim for bona fide requirement
Yes.
was upheld
Yes, madam.
in appeal.
Page 99, my lord, answer 8 is the judgment of the appellate court. I shall make it very short, my lord. I shall go directly to the, my lord, sorry, copy the judgment of excel first. My lord, para 8, my lord, at page 105, my lord. That is the, my lord.
Para 8. You can read.
Well,
Para?
para 8, my lord, of the appellate court judgment, which starts at page 99. No, page 10, yes, 99,
Page?
page 99, page 99.
Page 99.
Yes, page 99, the judgment starts, my lord.
Relevant?
11 portion is at page 105, my lord. Paragraph 8.
Yes.
Now, as regards the issue of bona fide requirement, issue number 4, in the evidence, plaintiff stated that the suit room is bona fide required for the plaintiff for business of his unemployed son of the plaintiff number 3. The plaintiff further stated that he planned to convert Assam type house into RCC building. The advocate for the plaintiff submitted that the suit premises is the marketplace within the heart of the Hailakandi round, having RCC buildings by side. And as such, he also plans to build a RCC building and extend his business. He also submitted that the suit room is more than 50 years old and in debtor condition, reconstruction is essential and just contrary to submission put forward by the land counsel for the defendant appellant. Nevertheless, it has come to forth from the evidence on record that PW1 Anita Das, the plaintiff authority, has a son, Saurabh Das, who is an educated unemployed youth, and as such, the need of the suit premises for business purpose. Suit premises being at the heart of the Hailakandi town is a business area surrounded by buildings, and the plaintiffs also intend to upgrade the Assam type house into a RCC building, and for that too, they need suit premises. Moreover, the suit house is an old condition that being the established position in the evidence record, I am considered opinion the plaintiff has been bona fide requirement suit for. Though the defendant appellant denied the same, but it does not hold good, he cannot incur loss to the landlord paying 105 per month. Well, this is absolutely no relevance that was so far bona fide requirement is concerned. Landlord. Say that he cannot incur loss to the landlord by paying 105 per month to quote, whereas the present rent is 7,000 to 800,000 per. If the landlord is the best judge for requirement of the residential business for business purpose and complete freedom of the matter. For judgment, the land court will rightly discuss the evidence on record, and I am the continuity of the opinion that plaintiff has bona fide requirement. This is the only, my lord,
Yes.
now, if your lordship will see, my lord, the plaint. It starts at page 17, my lord. I shall refer to page 19, paragraph 9.
Just a moment, you said page, college judgment starts at page
The judgment, my lord, at page 99.
99.
And I refer to, my lord, at page 105, paragraph. It's only one paragraph, my lord.
I think this is page 140, Annexure 8, judgment in title appeal 15 of 14.
Right. Well, I was supplied that book anyway, my lord, page 40. 140, if your losses take up 140, my lord, then it is at page 147.
140.
147. At page 147, my lord. Okay, it's equal to whether. 99 years. 99.
I'll go to judgment.
147 LOC got it,
Yes.
right. 147. Right. I read it again, better. As regards the issue of bona fide requirement, number 4, in the evidence, the plaintiff stated that suit is bona fide required for the plaintiff for business of his unemployed son of the plaintiff number 3. The plaintiff had stated that they plan to convert some type house into RCC building. Learned advocate for the plaintiff submitted that the suit premises is the marketplace within the heart of the Halagan town, having RCC buildings by its side, and as such, they also plan to build RCC building and extend his business. He also submitted that the suit room is more than 50 years old and in dilapidated condition. Reconstruction is essential. Just contrary to the submission, just contrary is the submission put forward by learned counsel for defendant. Nevertheless, it has come to the fore from the evidence on record that P.W. Anurita Das, plaintiff number 3, has a son, Saurabh Das, who is an adequate unemployed youth, and as such, need of the suit premises for the business. The suit premises being at the heart of the Hailakandi town, in a business area surrounded by buildings. The plaintiff also intend to upgrade some type old house into RCC building, and for that too, they need the suit premises. Moreover, suit house in old condition. That being the established position, evidence on record, I am of the contrary opinion that plaintiff has bona fide requirement for the suit premises. Though the defendant, the appellant denied the same, but it does not hold good. He cannot incur loss to the landlord by paying 105 per month, though court where the present rent in the locality is 7,000 to 8,000 per month. Well, this had nothing to do with the bona fide requirement, my lord.
Okay, we leave aside that
Yes,
line.
Yes. It is the landlord who is the best charge for requirement of essential business purpose and has complete freedom in the matter. The court below rightly discussed the evidence on record, so and so. So appellate court has not gone into evidence, nothing fully because the defendant evidence is there.
Okay, let's go to the evidence then.
Now, if the lawsuit see the plain first.
The court below, court of first instance must have discussed it.
I'm Page 73. Page 73, it starts, my lord, at page 126. No.
Yes.
LOC got it, my lord?
Yes, has got it.
The plaintiff claimed that the suit room is bona fide required for the plaintiff for business of the son of the plaintiff number 3. He the plaintiff father so that plan to convert some type house into a pakka RCC building, and as such bona fide requirement of the suit premises. The learned advocate for the plaintiff submitted that the suit premises is in the marketplace and within the heart of the Hailakandi town, having RCC building by its side. And as such, he also plans to build the RCC building and extend his business. He also submitted a suit room with more than 50 years old and in dilapidated condition. The learned advocate for the defendant submitted that there is a bona fide need of the plaintiffs, and as such, just pretended that as such the big defendant number 1, he submitted that the plaintiff had no project to convert the suit house, and also the son of the plaintiff number 3 runs a business elsewhere. Well, this is my hence he has no need, and the suit premises falsely claiming creation of new business without mentioning what sort of business he wants to do. The father submitted the suit premises in good condition, hence submitted that plaintiff failed to prove bona fide need of the suit premises. Let us look into evidence of both sides as to how the parties were successful in proving their P.W. Anurita Das, the plaintiff number 3 deposed that her son Saurabh Das, an educated unemployed, hence the need of the suit premises for business purpose. He further deposed that suit premises is being the heart of Halagan town in a business area surrounded by buildings. The plaintiff also intend to upgrade the Assam type suit house into RCC building, and for that too they need the suit premises. In cross-examination, she especially denied the assertion of the defendant side that he had no requirement for the suit premises. It 2 to 6 especially stated that in the examination chief that the plaintiff needs the suit premises for the employment of his son and also construction of RCC building but none of them were even suggested by the defense during prosecution about the non-requirement prosecutions. Period 7 Saurabh Das deposed that he is an adequate unemployed person and needs such premises to start his business. Further deposed that they corroborating his mother that the PD1, the suit premises situated at the heart of Hailakani town in a business area, and hence the old house needs because. In cross-examination, he especially admitted that he had a shop in the front of the house of Shipbari Road, which is given to on rent. So this is it. He denied the suggestion that he has a Xerox shop in the municipal complex and thus he has no requirement for premises. My lord, this is, my lord, we have exhibited one, my lord, municipal tax receipt, my lord. The defendant examined DW1 and failed to probe any suggestion regarding non-requirement of premises. During cross-examination, DW1 admitted that the premises surrounding premises RCC buildings, he admitted that house on the adjacent north and south and a multi-story RCC building and suit premises Assam type house so and so. He also admitted that his own shops elsewhere being run by his sons and shop belonging to him lying vacant in the side road. Further, the defendant stated that Saurabh Das, son of plaintiff number 3, has a shop in the municipality complex and adduced photocopy of a free receipt which showed that the shop is given on lease. Even on in this fact is taken to be true, a person having shop of his own in the heart of the town cannot be justifiably suggested to continue the business in a leased town, a leased room only, because he has given his house on rent. DW1 further admitted that during the prosecution, the plaintiff had competent sons who are in need of the witness. Upon minor scrutiny of the evidence on record, it is seen that the witnesses of the plaintiff duly stated corroborated each other that the suit premises is required for the business of the son, the plaintiff, and for upgradation, and stood firm during their cross-examination. But on the other hand, the defendant failed to probe his that rather admitted that the shop and others, the plaintiff competent person who are in need of business. He also admitted that the premises surrounded by suit premises have so and so buildings and of suit premises situated in the heart of the town. In respect of one of his requirement granted premises, the plan advocate for the plaintiff relied on so and so. In all the aforementioned cases, Honorable Supreme Court held that landlord is the best charge for the requirement. Further, the fact came up from the evidence of the defendant number 1 submitted. That the defendant is a defaulter and the plan for requirement. My lord, these facts are to be considered by the appellate court, my lord. In order 41 rule 31, my lord, it is the duty of the appellate court, my lord, because the last court, my lord, so far in its concern. There is no second appeal, my lord. So we have preferred the revision, my lord. It's a duty of the appellate court, my lord, to consider this evidence on the court, everything. Without considering a cryptic way, my lord, by one paragraph, he has rejected, allowed that, my lord. Now, if your lordship will see the plate, my lord. So there are various judgments of our High Court also, my lord, that
You cannot say it was not discussed. If we go back to para 8,
yes,
page 147.
yes, nothing has
It
been
says,
discussed.
as regards the issue of bona fide requirement, the evidence, the plaintiff stated that the suit room is, so some discussion is there.
Some discussion is there, my lord. The other, my evidence has not been considered, my lord, at all. My evidence has not been considered. that we have said that there is a municipal market and their shop is there. If your lordship come to page 63, my lord, we have exhibited that also. Page 63. Lordship, what is, my lord? What? Page 63. That is a receipt, my lord. This is business receipt regarding tax, my lord.
And that part is okay now, since we have read the trial courts.
The trial court is different, my lord.
No, we have understood.
Yes.
You are
So-
showing the receipt that is referred to already.
No, appellate court must consider everything, my lord. It is the appellate court duty, my lord, because there is a final court, my lord. So far, the Resident Control Act is concerned. Thereafter, my lord, the division we can file, my lord. This honorable court has held that no second appeal is maintainable. Full judgment is there. So far, this is concerned, my lord, this is first, even in other civil cases also, my lord, the appellate court has to consider everything, my lord. Because second appeal is also only on substance question of law, not other things. So for factual aspect is concerned, that the court must consider, my lord. And moreover, my lord, your lordships will see, my lord, the plaint, my lord. Plaint starts at page 17, my lord. I shall go to that, there, my lord, the bona fide requirement paragraph.
Yes.
Paragraph 9, the suit, at page 19. The suit house is situated
Page 19.
yes, page 9, para 9.
Page
Just
9.
No, page 19, para 9.
Para 9.
Last. This is according, leave. The suit house is situated at the junction of four roads, commercial area where need place are constructed 2, 3, 4-story RCC building. In that place, the suit house is too old wooden structure house, which the plaintiff are having capacity of RCC construction by way of demolishing the same, by which plaintiff would be able to earn more money, and the suit house is required by the plaintiff. The defendant was a financially sound person, and he is having means to pursue other business at his one of the sons of the is a contractor, and others one is having a shop. The defendant number one having his own houses. The plaintiff in his situation have no reason to keep that such tenant by of sustaining loss, since the defendant side failed to act at the earnest of the request of plaintiff. Having no other side failed to act at the earnest request of plaintiff, having no other alternative remedy, but suit has been preferred before the Honorable Court for ejectment of the defendant. So, my lord, it is admitted fact that, my lord, his sons are engaged, my lord. So, these, my lord, facts were not considered by the appellate court, which is the duty of the appellate court, my lord, being a final court of court, my lord. I shall refer a few judgment of the dishonorable court, my lord, so far. One of the requirement is concerned. My lord. My lord, first, my lord, judgment is 1992 GLR, page 461. I'll refer to para 9 at 464.
This one, Horen Borua.
Hello?
Horen Borua.
Yes, yes. Para 9, page 464. The next contention is the Khatri is that lower appellate court had not given findings about the bona fide and for bona fide requirement of construction, the landlord satisfied the court that landlord has sufficient fund or means steps taken in this regard. Khatri referred to the decision of the Supreme Court so and so. Supreme Court said, no doubt as to whether the landlord requirement is reasonable bona fide has to be judged by the surrounding circumstances, which will include the means for the reconstruction of the building and other steps taken in this regard. He has not said where the fund, where from it will be coming. He said only by means. Yeah, the above observation of Supreme Court has to be read in context of the case and scheme of Mysore Rent Act. In my opinion, expression bona fide means honest in the context. Bona fide requirement under the Act is to be referred from the facts and circumstances of each case. The court has to take into account all the surroundings, including not merely having sufficient means of or funds of the landlord for the construction, but also existing condition of the building, age, situation. It is sense of building happens, repetition, so and so. It may be the circumstance bona fide requirement of landlord, though that itself absence of means by funds or means or funds of the landlord for reconstruction would not be sufficient. In other words, the landlord having means or funds for reconstruction after demolishing the building itself may not be sufficient to establish the bona fide requirement if the building happens to be a very so and so recent construction. Sufficient means, funds means, and other steps so and so. As concerned authority may 11 establishing bona fide requirement. If there is no public motive which is established in the honest requirement of the sentence. So this is one. My lord, now I shall refer to my lord 92 1 GLR. Page 193. This matter, my lord, I shall refer to paragraph 13 only.
Paragraph 13.
13. The Act puts restriction on the right of the landlord to evict tenant from the premises occupied by him. This piece of legislation is a special legislation enacted mainly with a view to protect the interest of tenant. Under the same section, tenant cannot be evicted from premises merely on the whims and caprices of the landlord, provided he continues to pay the rent. The landlord, however, may seek eviction of the tenant if the conditions mentioned in clause A to G of the first proviso, section 5 of the Act is made out and under clause E, the landlord may seek a decree for eviction of tenant if the accommodation is bona fide required by the landlord either for purpose repairs or reconstruction for the occupation or for occupation of any person for whose benefit the house is. Similarly, under clause C, landlord may evict such the eviction for default. Therefore, one of the grounds for eviction of a tenant laid down under section 5 of the Act is bona fide requirement for a landlord for his own occupation. The word appearing in the clause C are bona fide. The word bona fide means honestly and good faith. It means a genuine and honest intention. Various dictionary meaning of the word bona fide only indicate the genuine and honest intention. The word required indicates something more than the desire. Well, this is very important. More than the desire.
Which paragraph are you reading? Which paragraph were you reading?
Paragraph 13, my lord.
1-3.
1-3. But I have given this 193, my lord, 92 1 jailer, 93 1 jailer.
No, that is 92 2 ZLR.
92?
Two ZLR.
Oh, I'm sorry.
Jagadish Chandra Paul.
I'm one minute. 92, kitna diya? One. For 92, one zilla. In para 10, my lord. 92, one zilla, 343, my lord. This 343?
That's not before me.
No, which one there?
Oh, this is same copy.
Oh,
92
sorry.
two ZLR.
Oh, sorry, my lord. I'm sorry. He had given wrong. I'm giving. 93, one jailer, page 190. No, yes, I'm sorry. I'm sorry. Wrong day given. I'm sorry. That's what- okay. Hmm.
92 to
Can you come in? Please,
Yeah.
Losses got it, hello?
Yes, yes.
The act puts restriction on the right of the landlord to evict a tenant from the premises occupied by him. This piece of legislation is a special legislation enacted mainly with a view to protect the tenant interest of the tenant. Under the same section, a tenant cannot be evicted from the premises merely on the whims and caprices of the landlord, provided he contributes to pay the rent. Landlord, however, may seek eviction of the tenant if the conditions mentioned in clause A to G of the first proviso to subsection 1 of section 5 of the act is met out and proved. Under clause E, landlord may seek a decree for eviction of the tenant if accommodation is bona fide required by the landlord, either for the purpose of repair or reconstruction, or for occupation, for his occupation or for occupation of any person for whose benefit the house is held. Similarly, under clause E, a landlord may seek eviction of the quarter default. Therefore, one of the grounds for eviction of a tenant is laid down in section 5 with a bona fide requirement of the landlord for his own occupation. The word appearing in clause E are bona fide required. The word bona fide means honestly and in good faith. It means a genuine and honest intention. The various dictionary meaning of the word bona fide only indicate a genuine and honest intention. The word required again indicates something more than desire. There must be an element of need in it. If a person really and genuinely needs something, he cannot be said to be require that thing. Therefore, the word bona fide connotes that the landlord genuinely and pressingly and honestly needs the premises in question for its use. The court as well as apex court have pointed out that the word required indicates that there must be an element of need and not a mere desire before the landlord can be said to require the premises for his own use and occupation. In Supreme Court so the word required satisfied that a mere desire on the part of the landlord is not enough, but should be an element of need, and the landlord must show the burden being upon him that he genuinely requires the non-residential accommodation for purpose of starting and continuing his own business. Therefore, where eviction of the tenant is sought on the ground that the house is not required by the landlord for his own occupation, the court is to see whether plaintiff genuinely and honestly requires the accommodation of his own use. A mere desire to have the accommodation would not be sufficient. There must be an element of need, and the landlord must show that he honestly required the accommodation for the purpose in question. Well, this is the matter. Now, well, I shall come to another judgment. Huh? It's for the दूसरा इसका कॉपी है ना कॉपी इसका my lord, now another judgment is there, my lord. 92 1 GNR page 343. 341. 10. As regards plaintiff's case for eviction of the defendants on the ground of bona fide requirement of the suit premises, I find that the learned courts below have arrived at the decision of number 3 arbitrarily without shifting the evidence and use the plaintiff in support of the contents. On issue number 3, the decision of the learned court that stated that suit house is required for bona fide use of occupation of the plaintiff, especially for the education of the children and plaintiff. In cross-examination, the DTO admitted that plaintiffs have no other accommodation at the Gauhati town. This issue can be decided in favor of the plaintiff. Learned appellate court below affirmed the decision of the so-and-so arbitrarily without discussing the evidence on record adduced by the plaintiff. In this case, ejectment of tenant on the ground of bona fide requirement, the burden is on the plaintiff, landlord. So-and-so, court by adducing evidence, and the suit premises is bona fide required by him. Mere desire of the landlord to get possession of the suit premises is not bona fide requirement. Court must shift the evidence adduced by the plaintiff and arrive at a satisfaction that the plaintiff landlord bona fide requires the tenanted premises. In the instant case, the plaintiff's vague statement that for education of their children they need the suit premises is not sufficient. Evidence adduced by the plaintiff should also establish that the education of the children would suffer if they do not start a residential establishment at the suit premises. For to the satisfaction of the court, the learned courts below failed to exercise jurisdiction or duly and vested in law is not considering the evidence of the plaintiff to derive at the satisfaction that the suit premises is really required by the plaintiff. The decision of the learned court below, issue number 3, therefore, could not be set. कॉपी होगा देखो तो होगा कॉपी I shall hand over one copy, my lord. That is another judgment, my lord. The appears, my lord, the judgment missing. 92 GLR, page 36.
Yes, that is what you had given 2 copies. That is why I sent back 1 copy.
Oh, yes. My lord, that your losses will come, my lord, paragraph 23 and 24. 23 and 25. Bona fide requirement of a landlord should be genuine, honest, conceived in good faith. The court must also consider it reasonable to gratify the need. Landlord desire for possession, however, honest it might otherwise be as inevitably be a subjective element in it, that the desire become requirement of law, have an objective element of the need. 24 various judgments referred to Supreme Court. Then, relying on the decisions, the learned counsel for the petitioner have submitted that while granting a decree for eviction on the ground of bona fide requirement, as contained in paragraph 5(1)(c) of the Act, the court must be satisfied from the evidence on record that there is a genuine need of the suit premises house by the landlord. Besides, the hardship of the tenant is one of the relevant factor to be considered by the court in so instance. Even if the question of comparative hardship is not examinable while deciding a cases covered by provisions of the Act, a court of law may not be able to shut his eye if the order of eviction of the tenant is throwing a tenant out of his occupation. In Medulal versus so Supreme Court, Apex Court held that mere assertion on the part of the landlord that he would require the accommodation in occupation of the tenant for the purpose of starting and continuing his own business is not decisive. It is for the court to apply objective test and is not subjective case. The burden is on the landlord that he genuinely requires the accommodation for the purpose of starting the business by proof. In Multimeter so, this court held that a vague assertion of expansion of the business is not enough. In the case, the plaintiff did not play a manner of business, no documentary evidence was adduced. So manner of business was option. established that a landlord genuinely required the shop. Therefore, the court rejected the bona fide. In Gedhailal versus District Judge, the apex court held that comprehensive hardship of the landlord and tenant must be taken into account. In Global versus so-and-so, the apex court has held that in case of even subsequent to the filing of the suit, inappropriate cases should be looked into. In the said case, plaintiff appellant constructed a spacious bungalow where with the members of his family resided. This was a bona fide, there was no bona fide requirement for a plaintiff, so-and-so. Well, this is, my lord, what I submit, my lord, that plaintiff itself, my lord, it says that both the sons are employed. Now they have come to a manner that for the unemployed son, my lord, is required, and we have produced a receipt also, my lord, that so appellate court has not considered anything, my lord. It's the duty of the appellate court, my lord, as per the, you see, my lord, there are various judgments, my lord, I have not brought today. I can do it, your lordship, my lord, that it's a duty of the appellate court, my lord, because the appellate court judgment is the final court of it.
Yes.
Trial court judgment is not enough, my lord, trial court. So this is a judgment, my lord, this is a case, my lord, which first, my lord, remand of the matter, but this is not a case, my lord, where. But appellate court has not considered all the points.
Next date.
Yes.
But in this matter, my lord, I make a plaint on the two grounds, one for defaulter and another for bona fide requirement. And the trial court decided both the issue in my favor. Ultimately, they preferred an appeal, and appellate court has modified the trial court findings so far as defaulter is concerned and decided the issue in the bona fide requirement in my favor, my lord. Yeah, my lord. Well then, learned senior, this read the judgment of the both the courts below, trial court as well appellate court below. One point raised by learned senior, appellate court has not discussed the findings of the trial court in details, and the requirement bona fide requirement is concerned respondent landlord, my lord. He says that it's not genuine. So, lordship, while my learned senior has read the trial court's finding in the issue number 4 bona fide requirement, upward rate, but later, what discussed by the learned trial court is also important, my lord. I'd like to draw your lordship attention at page 129 again, my lord. The issue is whether the court's trial court initially, first of all, trial court has discussed all the evidences of the prosecution side as well as the defense is not 129, my lord. So my learned seniors read the issue number 4 from 126. So I don't wish to trouble your lordship again. My learned seniors has read up to 129 first paragraph only. That is, the shop in front of the house is not sufficient to reject the plea of the bona fide requirement as the PW7 himself stated in this room is not vacant. Now thereafter, my lord. Hence, relying upon the aforementioned judgment, I am of the considered opinion that the arguments of the defendant side that the plaintiffs have other shops is not acceptable defense to reject the plea of bona fide requirement of the plaintiffs. The learned advocates for the plaintiff also argued that the Rent Control Act is admittedly formulated for the benefit of the tenant, but that should not be at the cost of hardship upon the landlord. In this regard, he relied upon the judgment of the Honorable Supreme Court, so. In this judgment, the Honorable Apex Court held the hardship of the landlords by not occupying their own premises would be far greater than one suffered by the tenant by moving to the another place. In the instant case, the defendant number 1 admitted during cross-examination the plaintiff's side has sons competent to start business. Yes, my lord. Even made an attempt to prove that a son of the plaintiff number 3 carries out a business in the leased out room of the municipal board. He further admitted that he has a vacant shop at some other place. It has also admitted that the premises surrounded the suit premises have multi-storied buildings. Hence, in my opinion, the need of the plaintiff is bona fide, and if rejected, would cause more hardship on the other than the defendant number 1. The defense further argued that plaintiff failed to show any project taken in hand for the upgradation, and thus this fact is not believed. The learned advocate for the plaintiff in reply argued when a suit is filed, it is uncertain as to when the result will come to the taken project in advance would be mere useless labor on the part of the plaintiff, because by the time the suit is decided, the estimated and even the permission if taken would get expired. Hence, the plaintiff did not move for any such plans prior to eviction. He further submitted that the first step to reconstruction of the building is to get it vacated, and the plaintiff has rightly moved in this direction by the filing the instant suit. I find force in the submission of the learned advocate for the plaintiffs, and prudency also demands that at first the building must be vacated. Thus, this argument of the defense is also not acceptable. Further, the circumstances came to clear show that the suit house situated at the heart of the town, surrounded by the buildings, and thus the plan to reconstruct the same cannot be rejected outright. Hence, in my considered opinion, the plaintiff successfully proved to the preponderance of the probability that they are in bona fide requirement of the suit premises. Thus, in the light of the above discussion, it is seen that every plea of the defendant has been negativated by the plaintiff and has supported his claim of bona fide requirement of the suit premises very well by evidence. It is an admitted fact that the suit premises situated at the heart of the Hailakandi town, being a business area, and as such, it cannot be rejected that a person who owns a plot in that area would wish to build a RCC building over there. Thus, in the light of the evidence adduced by both the sides and the judgment relied upon, I am of the opinion that the plaintiff landlord has a bona fide requirement for the suit premises decided in their favor. Here, my lord, admitted defendant number 1 in his evidence, he himself admitted, yes, there's a competent person in the side. The competent son is there who's eligible to start a competent business to start a business there. Admittedly, my lord, plaintiff number 3 is my the PW7's mother, my lord. See, the plaintiff as well as in the evidence is categorized. Yes, this is all dilapidated home. So we need to reconstruct for us in the heart of the Hailakandi and is situated for RCC building, and then Milot, and it is required for the son's establishment of business, Milot. This fact, Milot, learned trial court has discussed all this issue. Now, Milot, by learned the seniors, the appellate court ought to have discussed this point. I will draw your lordship attention the appellate court's findings again, Milot, at page 147, para number 8. The issue involved, Milot, whether plaintiff has made out his case so far as bona fide requirement is or not, whether defendant is admitted or not admitted. In this case, he simply said that, yes, this suit premises is a very 1970s constructed, wooden constructed house, Milot. We need for reconstruction, Milot. And my son's establishment business is required, Milot. This is the hard contention of the PW3 evidence, Milot. PW7 also in this evidence, yes, well, this room is required for my settled business in this regard, Milot. It is the landlord. They have it is their land. They are only the authority to decide their requirements, Milot. The tenant cannot dictate them what is to be done, what is not to be done. The tenant has no right. Now, Milot, in an appeal court's finding as para number 8, the moot issue is discussed or not. This is the important here, Milot. Here, Milot, the learned trial court's finding, this is issue number 4, bona fide requirement. In the evidence, the plaintiff stated that the suit room is bona fide required for the plaintiff for the business of his unemployed son. This is very important. Unemployed son. And even defendant also admitted this fact. Unemployed son of the plaintiff number 3. And the plaintiff's father stated that they plan to convert the Assam type house into the RCC building. The learned advocate for the plaintiff submitted that the suit premises in the marketplace within the heart of the Hailakandi town, having RCC building by each side, and as such, he also plans, Milot. He also plans to build the RCC building and extend his business, Milot. What is wrong on the part of the landlord? If he wishes to convert this peasant Assam type house to RCC building, my lord. What is this? Therefore, this reason we require that land, my lord. We require our tenant, we have tenanted him that premises we required. He also submitted the suit room is also more than 50 years, my lord. Kindly note this point. Suit room is more than 50 years old and in dilapidated condition. Reconstruction is essential. Just contrary is admission put forward by the learned counsel for the defendant appellant. Nevertheless, it has come to the force from the evidence on record that the PW1 Anita Das, the plaintiff number 3, has a son, Saurabh Das, who is the PW7 here, my lord, who is an educated, unemployed youth, and as such, the need the suit premises for his business. The suit premise being at the heart of the Hailakandi town is a business area surrounded by buildings. The plaintiff also intend to upgrade the Assam type old suit house into the RCC building, and for that too, they need the suit premises. Moreover, the suit house is in old dilapidated condition. Admittedly, my lord, that being the established position in the evidence on record, I am of the considered opinion that the plaintiff has a bona fide requirement of the suit house, though the defendant appellant denied the same, but it does not hold good. It cannot be incurred loss to the landlord so per month, though the court, whereas the present rent is total locality so. It is the landlord who is the best judge of his requirement for residential or business purpose and has complete the freedom in this matter. Since 1971, with the agreement, my lord, till now, my lord, the tenant is enjoying our land, my lord, and this matter was dismissed for default in the 2019. Thereafter, on 2025, they restored after 2,275 days. This honorable court has considered this. Since for the all the days, years, they enjoyed our land, my lord. And now also they are claiming that they are not allowing us to reconstruct our building from Assam type to RCS building, my lord. They are paying only the amount of meager amount of 105, my lord. No, whereas my land is the Hailakandi town, the heart of the city, my lord. I have every right to reconstruct my building, my lord. By one after another litigation, they are going to filing, my lord. And by this when they are delaying the process, they are enjoying our land, my lord. But what is our right, my lord? Now, my lord, and specifically, my lord, in the defendant, DW1, my lord, he himself admitted this fact. In the vernacular, it is only 3 lines I will read, my lord. বাদীপক্ষের পরিবারে যোগ্য ছেলে আছে যাদের ব্যবসায় প্রয়োজন আছে, that means what, my lord? Therefore, PW3 is claiming for business establishment for my son. This is PW7, my lord. He himself admitted that if the competent child is there in the landlord's family, my lord, and যাদের ব্যবসায় প্রয়োজন আছে, that means what, my lord? The business establishment is necessary for me, my lord. And, my lord, though my learned senior has relied various decisions of the apex court, my lord, sometimes swapping in a similar case, my lord, facts is different, my lord. A minute. My lord, I may be allowed to rely 3 citations. Both questions involve, my lord, whether that suit premises is required or admittedly, this is a 1950, more than 50 years old, my lord. Assam type wooden constructed Assam type house, we need for reconstruction, my lord. If thereafter, my lord, after RCC building we consider, my lord, after vacating the tenants, if there's a good relation developed between the landlord and tenant, if they wishes to offer that yes, we may be accommodated one room there to construct a building, it's a different issue, my lord. But for construction of the RCC building, the vacation of the tenant is very much essential. Then we could further construct it. Then some the question, this tenant and landlord will fresh agreement will come. Then if they interested, then a relation developed cordially between us. Then if he offers, my lord, the landlord of course he will think for re-establishment business of that land. But, my lord, he is not allowing us to reconstruct the building, and but on the dilapidated conditions house he is to continue his business. It is not at all permissible, my lord. Here, my lord, like the first citation, I like to rely, my lord. 2001 SSC 679, that is Raghavendra Kumar. And paragraph 10, only one paragraph I will read, my lord, here. May I read, my lord?
Yes.
The learned single judge of the High Court, while formulating the first substantial question of law, proceeded on the basis that plaintiff landlord admitted that there were a number of plots, shops, and houses in his possessions. We have been taken through the judgments of the courts below, and we do not find any such submission. It is true that the plaintiff landlord in his evidence stated that there were a number of other shops. Well, this is important, my lord. I can repeat, my lord. It is true that the plaintiff landlord in his evidence stated that there were a number of other shops and houses belonging to him, but he made a categorical statement that his said houses and the shops were not vacant and that the suit premises is suitable for his business purpose. It is a settled position of law. The landlord is the best judge of his requirement for residential or business purpose, and he has got complete freedom in the matter. And in this case, the plaintiff landlord wanted eviction of the tenant from the suit premises for starting his business, and was the suitable. It cannot be faulted. Here, my lord, we are having some other shops. We are having this. This is not Honorable Apex Court held that particular land premises is required or not. Admittedly, it had more than 50 years old wooden constructed house, assumpted, and we need to reconstruct to the RCC building, my lord. So we have every right to reconstruction in the very town, heart of the city, heart of the town, my lord. For more than 50 years, sometimes from paying low rent, my lord, he's enjoying till that, my lord. It is not at all prime. Absolutely, the bona fide method, the bona fide requirement is this issue is absolutely, my lord, in our favor, my lord. Now, my lord, my another citation, my lord, 2005 8 SEC 252. This is Said Nagji Purushottam and Company Limited. Only one paragraph I did, paragraph 4, my lord. Yeah, my lord. First of all, we shall take up the question of bona fide need of the landlords. So far as the petition, partition of the property.
Paragraph 4.
Paragraph 4, my lord. One paragraph only, my lord.
Yeah.
First of all, we shall take up the question of bona fide need of the landlords. So far as the partition of the property and the present premises coming to the share of the landlords are concerned, there is no dispute that the portion of the building has come to the share of the landlords, and they are the owners as a result of the partition of the family properties. But the question is whether the landlords who are the owners of the portion of the building have substantiated the allegation with regard to the bona fide need or not. We have gone through the findings of the trial court as well as the appellate court and the high court. And after closely scrutinizing the same, we do not think that the findings recorded by the appellate court and the high court can be interfered with by this court on the ground of being perverse or without any basis. The landlords have laid evidence to show that one of their sons, who had requisite qualification for starting a computer institute, wants to establish the same as Calicut, and others for extension of their business. The trial court as well as the first appellate court and the high court examined the statement of the PWs 2 and 3, and after considering their evidence, the appellate court reversed the finding of the trial court and held that need of the respondent landlord to start a business at Calicut is bona fide and genuine. It was held that it cannot be said that a person who is already having a business at one place cannot expand his business at any spreading over Chennai and Hyderabad. And if they wanted to expand their business at Calicut, it cannot be said to be unnatural, thereby denying the eviction of the tenant from the premises in question. It is always the prerogative of the landlord, and that if he requires the premises in question for his bona fide use for expansion of business, this is no ground to say that the landlords are already having their business at Chennai and Hyderabad. Therefore, it is not a genuine need. It is not the tenant who can dictate the terms to the landlord and advise him what he should do and what he should not. It is always the privilege of the landlord to choose the nature and the business and the place of business. However, the trial court held in favor of the appellant's tenant, but the appellate court as well as the high court, after scrutinizing the evidence on record, reversed the finding of the trial court and held that the need of the establishing the business at the Calicut by the landlord cannot be said to be lacking on the bona fide. My lord, the Honorable Apex Court appreciated the findings of the appellate court as well as Honorable High Court's, my lord. So far as if the landlord wishes to expand his business for his business establishment, landlord is the competent authority to decide on this one, not the tenant, my lord. The last one is, my lord, that is Air 1991 Supreme Court 353. That is the Shyamal Agarwal versus Ratanlal Malavia. Here, lordship, I will read only 4 and 5. So, okay, I'll read, my lord, 5 also. Paragraph 4, my lord. In the instant case, the appellant's grievance is that the courts have not recorded the findings with regard to the bona fide need of the landlord is devoid of any merit. There is a clear finding recorded by the subordinate courts on evidence on record upholding the landlord's bona fide need of the accommodation for rebuilding the same. The High Court referred the trial court the finding that on admitted facts, similar adjacent shops which are not vacated by the landlord on the ground of rebuilding have already been rebuilt and the landlord was possessed of sufficient means for the purpose. The High Court further observed that both the courts, namely the trial court and the first appellate court, recorded the finding on the question of bona fide need of the landlord. Those findings could not be ignored on the mere ground that the accommodation in dispute was not in dilapidated condition. As already discussed in Soicho, the Act does not provide that the accommodation for the purpose of reconstruction must be in a dilapidated condition. The courts have considered relevant facts and circumstances in upholding the landlord's claim for reconstruction of the accommodation. The High Court's order does not suffer from any legal infirmity warranting interference by this court. Para 5 below. The Learned Counsel for the Tenants states that the tenants would like to have the shop in dispute, dispute under this tenancy after it is reconstructed as provided by the Soicho. We therefore direct the appellant shall hand over vacant possession of the shop within 2 months from today to the respondent, and they will reconstruct the building within 1 year. And after reconstruction, the respondents are directed to offer a new reconstructed shop to the appellant on a fair rent within 1 month from the date of completion of the construction, my lord. My very purpose to read this paragraph 5 specially, my lord. So there is no specific instruction from a client, my lord, but court has to balance the requirement of both the sides, my lord. Admittedly, at present, my lord, that
What after building you will offer him?
my lord, after rebuilding, my lord, this is the only option left there, my lord. Let us reconstruct our building, RCC building, my lord. When we construct the various room will be there, then he is agreed to offer his rent at that part at present value, my lord. Then no denial on our part, my lord. On that observation, instead of keeping one of the litigation, then lordship will find the matter to remand the appellate court, and the appellate court will decide the issue, and then thereafter again to High Court, then Supreme Court, it will continue, my lord. But that dilapidated room is still, we are suffering, my lord. Let us construct our building, and we get for benefit from that by construction RCC building. And he would be benefited if he wants to do business there, my lord. It is a subsequent, it will come, my lord. But at present, he cannot say that only technicality ground, on this evidence ground, it is not discussed, the appellate court is not this. No, my lord. Very important is that admittedly the 50th old building, my lord, the RCC wooden constructed house, my lord, we need to reconstruction, my lord. After reconstruction, they have to vacate the land. So we construct, then after the agreement will come, and terms and condition of rent will come, my lord. And this is so, my lord, the court below had decided, the trial court has decided both the issue in my favor, but the appellate court has modified that for as defaulter is concerned when bona fide. So my only in respect concerned before this court below, the court below has decided, discuss all the point, and most importantly, my lord, he himself admitted by the tenant that in my family there is a competent members is there who need for business, my lord. Then what that is, therefore we want to reconstruct a building and to restart our business, my lord. So no interference at all sort, my lord. Obliged, my lord.
My lord, my humble submission is this, my lord, that the appellate court has not considered any appeals. Appellate court, because
You have already made that point.
I have, because there are various judgments. If my lord, tomorrow I can give one judgment, my lord, on this point, the duty of the appellate court. And moreover, I have said that, my lord, he has his son has a business, my lord, on such and such, and I produced that. And in the plaint also, the plaintiff admitted that his both sons are employees. She don't follow the things, my lord.
Yes.
I can submit one judgment on the duty of the appellate court, my lord, tomorrow. There you go. I forgot to bring it. The information to Mr. Decker. Correct.
Obliged, my lord.
Number 16.
Please, Your Lordship. My lord, I pray for little accommodation for today, Lordship.
21.
Yes, I am for respondent.
5th of March, Lordship. Obliged, Lordship.
Most obliged.
Regular bail petition, Your Lordship. Petitioner is in custody for Your Lordship 188 days, Your Lordship.
Receive.
Initially, Your Lordship, the case was registered under section 21B and 29 of the NDPS Act, Your Lordship.
27A.
Initially, the case was registered under section 21B and 29 of the registration, 29 of the NDPS Act, Your Lordship. Later on, Your Lordship, on the prayer of the IO, Your Lordship, section 27A and 29, reduced section 111 of the BNS was, Your Lordship, added, Your Lordship.
Is the
After-
quantity intermediate?
Intermediate, Your Lordship. Not, it was not recovered from the petitioner, Your Lordship. It was recovered from someone else, Your Lordship. Petitioner was arrested on the basis of confession of the Your Lordship main accused, Your Lordship. And the main accused has already been released on bail, Your Lordship. I have annexed the order, Your Lordship. And Your Lordship, after filing of the charge sheet, Your Lordship, now the charge has been framed, Your Lordship. And charge has been framed, Your Lordship, under section 21B, 29 of the NDPS Act, reduced section, Your Lordship, 1112 of the BNS, Your Lordship. Section 27(1) is not omitted, Your Lordship. 7(1), it is not your
To
frame.
have it. Charge sheet.
That is the Lordship. I have taken my kit, Lordship.
Order dated, Your Lordship, 8/10/2026, Your Lordship.
Lordship, his involvement is there, but court has not did that section. But
36, 37 will not be attracted.
Not be attracted.
27A is not there.
To page 36. Dated 24/5. 1, 2. Continue with 3. It is further submitted that in the meantime charge sheet has been set in the case wherein section 27A has been omitted. And therefore the rigor of 7 of the NDPS Act is affected. Further appears that the main accused of the case, from whose possession contraband was covered, has been released on bail by
Order dated 18/9/2025, Your Lordship.
in
And Annexer F, Your Lordship, page 30.
in 925. Gauhati PSC number 363 of 25 by the learned special. Having regard to the above and consideration of the fact that the recovery involves intermediate quantity, a period of detention of how many days?
As on date, Your Lordship, 188 days, Your Lordship.
88 days. Therefore, bail is allowed. Provided that the petitioner shall regularly participate in the trial in any manner accordingly.
I'm deeply obliged. Kindly call for time being. My senior is appear for another.
But time being, we have no other. See appeal. Into আছে নেকি? 18. Time being, we'll wait here doing nothing. Twenty-one matter. 21 or বেশি পুরনো matter নহয়। What did be the বেলেগ এটা? 120. It will have on another date then. What is it?